Welcome to SCOTUScast, a project of the Federalist Society for Law and Public Policy Studies. Our contributors join us from around the country to bring you expert commentary on U.S. Supreme Court cases as they are argued and decisions are issued. The Federalist Society takes no position on particular legal or public policy issues. All expressions of opinion are those of the speaker.
Thank you for tuning in to the October 2021 term of SCOTUScast. I'm your host, Nick Garfinkel, on behalf of the Faculty Division of the Federalist Society. On December 8th, the court heard arguments in Carson versus Makin, a case which concerned whether a state violates the religion clauses or equal protection clause by prohibiting students participating in an otherwise generally available student program from choosing their aid to attend schools that provide religious or sectarian instruction. Joining today to discuss this decision in two parts is Nicole Garnett, the John P. Murphy Foundation Professor of Law at Notre Dame Law School. This episode will begin with coverage of the question and background, and then proceed in second part to focused analysis of oral argument.
So Carson versus Makin is a religious liberty case. The question in the case is whether the state of Maine can exclude religious schools from a school choice program. Maine, Vermont, and New Hampshire have kind of an unusual system of funding secondary education. They are all rural states, and many school districts in those states don't have public high schools. So in Maine, also in Vermont, and to a lesser extent in New Hampshire, if you live in a district without a public high school, the district is given an option by the state. The district can either contract with another district to educate the kids that would need a secondary education in that district, and most in Maine do that. Or it can do what's commonly called tuition them, which is just basically give them the money that they would pay for the contract, about $10,000, I think, in Maine. And they can use that at the school of their choice, public or private. Maine's tuitioning program has been around since 1873. So the tuitioning money, the money that you would get if you live in a district that does not have a public high school, that does not contract with a public high school to educate you, you can use anywhere in the world. You can use it at a public school, a private school. Many kids use it at boarding schools, elite prep schools. There's some kids who have even used it at foreign boarding schools. But there's one restriction, which is that you may not use it at a religious school, a school that the state of Maine deems sectarian. So there's no question in this case that Maine could, if it wanted to, allow kids to take the tuitioning funds and use it at a religious school. That question has been resolved for over 2 decades now since the Zellman case upheld school vouchers. And in fact, Maine did allow kids to go to religious schools before 1980. In 1980, in response to a request by the ACLU, the Attorney General of the state issued an opinion letter that said that it would violate the Establishment Clause of the federal Constitution to allow kids to continue to use the tuitioning money at religious schools. And since then, Maine has not allowed the kids to use their tuitioning funds at religious schools. This is even since Zellman. This program has been challenged a number of times, including by me many years ago. But things have changed since 1980. The law has evolved in a variety of ways. The first is, of course, Zellman. In 2002, the Supreme Court upheld a voucher program that allowed poor kids in Cleveland to go to private schools, including religious schools, with public funds. In fact, 96% of the children participating in that program went to religious schools. And then in subsequent cases, the court starts demanding this sort of adopting a rule that the free exercise clause in the funding context, what it demands is neutrality, not hostility to religion. So it begins to suggest in a series of cases that a program of funding, a public benefit program that excludes religious schools or that prohibits kids from using or beneficiaries from taking advantage of public benefit programs because they are religious violates the free exercise clause. So interestingly, the First Circuit, I'll talk a little bit about what happened below, but the First Circuit upheld the Maine's exclusion of religious schools. Within a few months of that, the Second Circuit struck down Vermont's exclusion of religious schools. that may be one of the reasons the court took it. There's a clean circuit split now on this issue and almost identical programs. There are really three cases that are important to the court's deliberation about whether or not this exclusion of religious schools violates the free exercise clause. Two of them are relatively recent. In 2017, there was a case called Trinity Lutheran. In Trinity Lutheran, the state of Missouri said that its establishment clause, its Blaine Amendment, this Missouri Establishment Clause, required it to exclude a religious preschool from a program that provided recycled tires for preschools for playground resurfacing. The Supreme Court said that violated the free exercise clause because it was discriminating against the preschool because it was religious. It was religious discrimination and therefore was not neutral toward religion. And then just last year in a case called Espinoza versus Montana, the Supreme Court held that when the Montana Supreme Court invalidated a very small tax credit, a small private school choice program in Montana on state establishment grounds, because it included religious schools, it violated the free exercise clause. Again, the court says if you have a general program, public benefit program, you may not exclude religious schools except without violating the free exercise clause, because that renders that program discriminatory and not neutral toward religion. So in both Espinoza and Trinity Lutheran, the majority, both opinions written by the Chief Justice, leaves open the possibility that there may be a distinction between discriminating against a provider or a school based upon the religious character of that institution and discrimination that is sort of motivated by a desire not to pay for religious activity. So what happened in the First Circuit is the First Circuit said, well, this was motivated by the latter. Maine is not discriminating against these schools because of their religious character, but rather it's making a decision that it does not want to fund religious education. The court says that the First Circuit said this so-called status use distinction justifies the exclusion of religious schools from Maine's tuitioning program, and therefore the program is constitutional. Again, the Second Circuit finds earlier this spring the opposite. One little interesting tidbit about the First Circuit opinion is that Justice Souter was sitting by designation. So in one sense, the question in the case turns on whether there is this distinction that allows states to just decide we don't want to pay for religious education. Is that distinction different between the character-based discrimination? I'm discriminating against you because you are religious, and I'm discriminating against you because I don't want to pay for religious uses. There is a third case that will play a role, which is a case called Locke versus Davey, which is a 2003 case. Locke involved a similar challenge to a program, it was a Washington scholarship program that said you could use money to go to a religious school, but not to train as a minister. And the court upheld that based upon it's articulated a state interest in not paying for ministerial training. So on the one hand, you have these two cases, Trinity Lutheran and Espinoza, that say no religious discrimination, no exclusion of religious beneficiaries. On the other hand, you have Locke, which says it's probably okay. It's okay to not pay for ministerial training. So my prediction is the court did not take this case to affirm the First Circuit. I think the Supreme Court will find that the status use or character use distinction is a distinction without a difference. I actually filed a brief in this case representing Catholic, Muslim, and Jewish schools, and all of our clients in amicus brief, they would make the case that what it means to be a Muslim school is to teach Islam. What it means to be a Catholic school is to teach Catholicism. So there is the status use distinction is for schools in particular is the same thing. To discriminate against a school because of its Catholic character, Muslim character is also to discriminate it against the school because it teaches religion. I don't think Locke versus Davey will be dispositive. I think the court in Espinoza made a very big effort. The chief made a big effort to try to say that was just about ministerial training. Another little thing in the weeds is that in Locke versus Davey, the Supreme Court made a big deal out of the fact that the Washington Constitution was more restrictive than the federal establishment clause, and Maine doesn't have an establishment clause. So that's another distinction. Okay, so that's Espinoza, and I'll just say a couple things about implications. There are a lot of implications here. The first is that the school choice movement has exploded in the United States. There are now 31 states with school choice programs. And I think the biggest implication is this would further clear the way for more school choice and more legislative experimentation in the states, because it would probably make it very difficult for states to rely on their own establishment clauses to invalidate voucher programs. And the second thing is that this status use distinction, if the court says there is no distinction between religious status discrimination and religious use discrimination, there are a whole bunch of other programs, including the child care provision of the Build Back Better that have these restrictions on expenditures for religious purposes that would come into question.
This concludes the first segment of Carson versus Makin. In the following section, we'll hear more focused analysis of oral argument.
The Supreme Court heard oral argument in Carson versus Makin on December the 8th. It would be fair to say, in fact, it would be an understatement to say that the case and argument went well for petitioners. The hardest questions for petitioners came early, and they were about standing. In fact, the first question from Justice Thomas was to the petitioner's attorney, tell me why your clients have standing. The standing difficulty in the case is that the petitioner, who is the mother of a parent of a young woman who qualifies to get tuitioning money from the state of Maine, but wants to use it at a religious school and can't because religious schools are excluded from their program. This young woman has indicated that she wants to attend a particular school, or maybe two schools. Neither school has ever indicated that they will apply for the program if they are permitted to do so. The petitioner's argument is that the standing issue is not insurmountable because, first of all, it makes no sense for these schools to even bother applying to participate in the tuitioning program because they clearly do not qualify. And second, if they did not qualify through the application process, the petitioners have indicated that they want to send their child to a school that reflects their religious beliefs. It seems to me that this standing argument is not insurmountable. The program allows for the money to be used anywhere in the country, and it's clear that the petitioners here only want to use it at a religious school. So even if the school that is preferred by the petitioner didn't apply or was rejected for reasons unrelated to religion, the petitioner could go somewhere else to another religious school that meets their needs. The standing questions came from Justice Thomas, Justice Barrett in a particular way, and Justice Kagan toward the end of the argument seemed to also embrace very strongly the view that the petitioners did not have standing. Early in the argument, Justice Breyer said that the school itself would not qualify because it discriminated against students and teachers on the basis of LGBTQ status. The petitioner's attorney tried to explain to Justice Breyer that that was not in fact the case because Maine's discrimination law has an exemption for religious organizations. It seemed to flummox him a bit, but finally he gave up on that line of argument, and it became clear that the school could apply, that this religious view would not be a major impediment to them participating in the program. The toughest questions from the more liberal justices did focus on, to petitioners at least, on this discrimination concern. Isn't this bad? Isn't this school going to discriminate? This didn't really seem to have anything to do with the program itself, because the program's only exclusion here is for religious schools. One of the most interesting things about the argument is that going into the argument, everybody thought that this case was about whether there is a constitutional distinction between discrimination based on religious use and discrimination based on religious status, and none of the justices seemed interested in this at all. The Chief Justice, who came up with this so-called almost distinction, was completely uninterested and, in fact, peppered the state's attorney with a lot of questions about how much religion would be too much. state's attorney got flummoxed and said something like, well, we excluded one school that had a chapel because they said the chapel was important to them, and we didn't exclude another school that had a chapel because they said it was only used for secular activities. And so the chief spent a lot of time saying, well, what if they only had one religion class? What if they only had a religion class on Friday? What if they only went to chapel once a month? It was clear that he wasn't vying his own status use distinction. Justice Gorsuch really reacted to the state's effort to answer this question by asking a very good question, which was, aren't you now discriminating between religions? Because you say, well, the parents can always use Sunday school, but maybe that's good enough for Protestants, but not for Catholics and for Jews. So it's sort of the status use distinction questions went nowhere. The other kind of elephant in the room coming in was the Locke v. Davey case, and it only came up once. And that's when Justice Kavanaugh said to the petitioner's attorney, in order for you to win, do we have to overturn Locke v. Davey, or could you just tell me we could distinguish it? So obviously no one thought, or at least 6 justices did not seem to think Locke v. Davey was an insurmountable hurdle to the petitioner's winning. I think the most bizarre thing about the argument was that it wasn't clear that the state's attorney and the SG, the U.S. attorney, SG that is, hadn't forgotten that it was not the 1970s. Their arguments were based on law that doesn't exist anymore. The state kept talking about how its interest was replicating a Maine public education, not the status use distinction, but rather that's doing its best as a small rural state to replicate a Maine public education. This was a new interest, as a couple of justices pointed out, because the program included religious schools until 1980. Justice Alito humorously asked, are you telling me that sending kids to Andover and Exeter replicates a Maine public education? The answer was yes. What about boarding schools in California? The answer is yes. What about Miss Porter School, which is apparently an elite boarding school for girls in Connecticut that charges $65,000 a year in tuition? The answer is yes. That replicates a Maine public education. Why? The answer was, well, because they're secular. So the only thing, according to the state, that makes a public education is that it is secular. And it was clear that the justices, or at least 6 justices, had no patience for this. The U.S. argument, the SG's argument, was that the state had an anti-establishment interest in keeping religious schools out of the program. Justice Thomas asked, what are you talking about? What is an anti-establishment interest? And then in a really bizarre throwback kind of argument, the deputy SG went on about how if you were allow religious schools to participate in this program, there would be deep religious divisions in the state of Maine. Justice Breyer was a big fan of this particular argument. He went on and on about how dangerous the divisions would be if you allowed religious schools to participate. But he also admitted that he had made these arguments before, always in dissent, when he voiced it in opinions. And then Justice Alito and others asked questions about whether there was ever any evidence that the inclusion of religious schools until 1980 had ever fomented any religious divisions. And, of course, the answer was no. So in the bottom line is there is a standing hurdle, probably not insurmountable, and it seems pretty clear that the petitioners will win. One final note, which was interesting, is this case was entirely argued about education. It has vast implications for other kinds of social services outside of the education sphere. That didn't come up. But it will inevitably lead to, if Carson versus Makin is decided in favor of the petitioners, the court holds that the exclusion of religious schools from this program of educational benefits violates the Free Exercise Clause, will lead to more, I think, challenges to exclusions or requirements that charitable providers that are religious secularize their services. So that's sort of the next line.
Thank you for listening to this episode of SCOTUScast. SCOTUScast is a project of the Federalist Society, a not-for-profit educational organization of conservative and libertarian law students, law professors, and lawyers, founded upon the principles that the state exists to preserve freedom, that the separation of governmental powers is central to our Constitution, and that it is emphatically the province and duty of the judiciary to say what the law is, not what it should be. Don't forget to subscribe to our podcast series, including SCOTUScast and Practice Group podcasts, on iTunes or Google Play. For an archive of past podcasts, as well as audio and video of past Federalist Society events, please visit our website at fedsoc.org/multimedia. That's fedsoc.org/multimedia.
This has been a FedSoc audio production.